Hi, everyone. Good to see you guys all today. There's some big things we want to cover today. The first being that now there is a new $1,000 fee. And most people think that this only applies at the border or at the airports, but you will be wrong. The new $1,000 fee, if you're entering the United States, can also be at USCIS because USCIS issues these parole documents as well. So anything that is parole related, you have to pay the $1,000 unless you fit one of the exceptions. This is brand new and it is effective immediately. So if you're traveling into the country and you need some sort of parole to get back in, to get in the country, there's that $1,000. Now, the people that this is definitely going to impact the most by far is everybody who's on DACA, right? So everybody who's on DACA who applies for advance parole, well, that's a parole. So when you're re-entering the U.S., you pay that $1,000. You first pay the USCIS Advance Parole filing fee, so that stays the same. But once you get it, then you leave the country, you come back in, boom, you're hit with another $1,000. And this is effective immediately. Now, is it worth it to pay for that $1,000? If you have a spouse who is a U.S. citizen, if you have another U.S. citizen in your family that can file for your adjustment status case, sure, it's an extra dinger. Think of it like a major traffic ticket. But if it helps you get the green card, it's probably worth it. It sucks. It's extremely unfortunate that the government issued this, right? And again, who's primarily paying for this right now? Again, mostly DACA applicants. Now, in the future, and if this continues indefinitely, right, next 10 years, potentially everybody who's applying for humanitarian parole all pays for this $1,000, and it's an extra income for the customs officers. Okay, but it just looks like fraud, right? Like, especially right now, you never knew about it. It never existed before. You have a travel permit, you have a travel document, an advance parole. You leave the country, come back in, and custom pulls you in, hey, pay $1,000. But, and I haven't seen a lot of news coverage on this as well. I mean, a few TikTok videos here and there, but again, this is something that's brand new. Clients are getting it all over. We've been doing a bunch of consultations. Is this fake? Is this real? It definitely is real. The thing is, it's not even on a CBP website. I just checked right now, not even there. It's on Department of Homeland Security website. It's on USCIS website. But again, they only briefly mention it to CBP. But I know CBP is executing this already, right? So again, if you are traveling on parole, even if you've already executed it before, right? Like you have a multiple travel document, multiple entry travel parole document. And let's say you just left, in September or August, this policy wasn't in effect yet. And now if you're going in November, December, this time coming back, you're going to have to pay that $1,000. Who doesn't it apply to? Well, they listed out a bunch of exceptions. We're going to put the link down. We're going to put a screenshot so you can see it. But essentially, major humanitarian reasons, maybe they can exempt it. You're going to cause a major benefit to the United States. The United States government needs you. They're not going to make you pay for it. But a lot of times, if it's individual reasons, you're traveling with advance parole, you're a DACA recipient, you're traveling for work, for family, they're going to make you pay the $1,000. Okay, we'll start taking questions before we hit the story.
Okay, so this is just my question. How is setting this $1,000 fee legal? And what's stopping it from making like $100,000?
Sure. The president have executive authority over the border, so they don't need congressional approval. Parole is not a congressional right to be in the United States. It is not like a citizen. It is not like a lawful permanent resident status, a green card holder. It is not like a visa, right? So canceling visas overseas, that's already within the jurisdiction and purview of the United States executive branch under the president. And so just like what we see with the H-1B 100,000 fee that they could slap on, they already have that authority. Parole is one step below that. Parole is saying, all right, visa takes too long, we'll let you in temporarily. So people with parole have almost no right whatsoever. And under that purview, the United States government is saying, well, now we're going to charge $1,000 fee. You can equate it kind of to thinking like, oh, It's similar to a visa application fee, right? So a lot of visa applications, let's say H-1B, a E-2, an O-1, you file an application fee with the United States Citizenship Immigration Services. You might have paid $3,000-$4,000 with the filing fees on its own if you do premium processing. And then you go to the consulate and you pay some more before you get a visa for you to enter. A lot of people, when they're applying for humanitarian parole, they don't pay anything. There's no paperwork. And a lot of people have gotten in over the past decades. Now the government is saying, nope, you're going to pay the $1,000 fee. This entire year, by the way, humanitarian parole has pretty much been canceled, right? We used to do a lot of them prior to this year. People who have urgent, sympathetic reasons, you talk to a CBP officers, they understand, they let you in. You don't pay any fees, right? And then you leave. Now, this entire year, that's been canceled, and this thing comes out. Maybe that's good news for people who want and need humanitarian parole. So now there's actually a way for them to do it if they pay the $1,000. To the best of my understanding, as of right now, CBPs are still not really willing to adjudicate humanitarian parole cases. There's a lot of red tape around it, but maybe this is just the first step, right? Now there's a fee associated with it. Now the government is tracking. There's a database of some sort, and maybe 1, 2, 3 years, hopefully not too long, maybe 1, 2, 3 months later, maybe next year in January, the 1-year anniversary of humanitarian parole being canceled, maybe they'll restart it. And, if every port of entry, there's 100 people who use humanitarian parole a day, 100 times 60 plus times 1,000, that's a nice size revenue for the government.
We said who it applies to, right? Everyone who is paroling in.
Yeah, here, I have the list of who it does not apply to. So first, if you're a U.S. citizen, it doesn't apply to you. If you're a green card holder, it doesn't apply to you. But if you have a visa, you have a B1, B2 visa, you have a H-1B visa, it doesn't apply to you. It applies to people who are entering the country or trying to stay in the country as a parole. Now, you're supposed to pay $1,000 unless one of these exceptions applies. So medical emergency, the government needs you. You are in the process of doing an adjustment of status, and so it was a temporary leave. There's 10 exceptions that qualify. So even if you are coming back as an advance parole or any sort of parole, a humanitarian parole, you don't have to pay. With that being said, it's most likely the case, everybody who's doing this on a regular basis, DACA, advance parole, they're going to be paying the $1,000. People in the future, humanitarian parole, they're paying for this. Any sort of parole in the United States, through the decades of being here, they have to be continuously paroled in the United States. They have to pay the $1,000, right? So it becomes a massive subscription fee model for the United States government. One can argue that this is fair. I just wish they were a little bit more clear on that, right? Because again, as the government does, they're saying it's for, security purposes that they're doing it. Well, I don't think that's exactly right? But with that being said, $1,000 for parole, it might benefit a lot of people who need humanitarian parole. People are gladly willing to pay $1,000 to attend their mother's funeral in the United States, and the visa process takes 2 years, so they're willing to pay that $1,000. So, but it is a lot of money for a lot of people around the world.
Yeah, do I need a lawyer for a naturalization interview?
Now, for your reference, our firm takes on very difficult cases. With difficult cases, almost 80% to 90% of the cases, we tell them you do not need an attorney present with you at the interview. So we are already a very difficult, sample size, right? We are already dealing with some of the most difficult cases, and we're still saying you don't need to. Now, again, take that with a grain of salt. Every case is different. Let me give you some background. The attorney cannot talk, right? So when you go to the interview, the attorney sits in the back of you. I've been to plenty of these interviews myself, the company clients. We can't talk. Officer won't let us. The only time we're effective is if the officer doesn't quite understand, or if they're racist, or if they're adjudicating something extremely bad, or you have a very difficult case and you need, supervisory review. Then the attorney steps up and talks. Again, most of the cases that we do are already complicated. Most of the cases still get approved. some certain situations, it's definitely better to have that extra assurance, but it is not something that we say everybody needs. Now, some attorneys will say, just always lawyer up every single time. In my experience, in my personal opinion, I don't think that's necessary.
If your case says fingerprints must show taken, what does that mean?
Fingerprint must show that it is taken, meaning if you have a biometrics appointment, a fingerprint appointment, and it needs to be done. That's how I'm reading it.
Recently, the U.S. government has acknowledged the Christian killing in Nigeria. My spouse is currently waiting for a pending I-130 filed 2 years ago. I recently filed expedited using this. Now, financial burden option. Can I file again using the humanitarian option since she's living in the north where all the killings are happening? What do you recommend to make a solid expedite case?
Oh, yeah. We've definitely had a lot of cases expedited with these type of news reports. So my recommendation, provide maybe 10, 20, maybe even 30 news article sources with a map of everything that happened and where she lives, right? Proximity, and if there's any notes or threats and neighbors and testimonials, include that as well, include it in the text, right? So use that all as evidence, and then a half a page letter explaining the urgency with a list of all the documents and sending it in. And then also re-mention again that you've already been waiting for 2 years.
My I-751 is 15 months pending. Should I apply for citizenship now?
15 months pending. So presumably you've already been married for 2 years. Now it's 3 years. You're married to a U.S. citizen. If you really want the U.S. citizenship and you want to expedite 751, yes, right? We tell that to our clients. Now, most of the time, what will happen is that your citizenship interview might be scheduled even before your 751 gets approved, right? Because again, 751 could take as long as 3 years. So what will happen is you go to the citizenship interview, you pass everything, and that citizenship officer either will force the other officer to adjudicate it, or they have pulled the case and adjudicated it on their own. And then just both gets approved simultaneously, but instead of giving you a new 10-year green card, they just give you oath ceremony and then you become a citizen.
Can I travel within the U.S. as DACA holder with a clean record?
Yes, legally you are. We just did this live last week or last week. A DACA holder, one of our clients, was traveling in a domestic airport, and a CBP officer cornered them, husband and wife, and was challenging them their legal status. It was a very dicey situation. So my recommendation is carry proof of your DACA approval.
I'm U.S. board certified trained physician working in Europe, 100 plus citations plus judging experience. Can I look toward EB1A or O1 to avoid the $100 fee? This is the commentary from last.
$100 fee?
100,000.
Oh, 100,000 for the H-1B. O1 and EB1A are completely different requirements, although they overlap significantly. O1 will get you into the U.S. much faster than an EB1A, right? Because EB1A, you file it, it gets approved. Both you could do premium processing, and then you still have to go to the consulate, and then you have to get the visa. So it could potentially be an extra, 6 months to 9 months delay if you do EB1A. Both seem viable. You could always do O1 first, come in, and then do EB1A in the U.S. So if you have people who need your work, and I remember last week you asked this question, if you're already able to work in the U.S., you provide that proof, you get the O1, you go to the consulate. The consulates in London, I remember, is pretty fast. We did a lot of O1s in London. So it's if you want to come to the U.S. fast with your family, O1, then EB1A. If you could stay in Europe for a little longer and your case is really good, then you could just directly do the EB1A and skip the entire cost of the O1.
Oh, I didn't realize that this question was taken out from the full live when we posted it. I also have approved EB2 and IW with a current priority date.
So the little tricky part is that O1 is not exactly dual intent, which is the problem. You still apply and still try. The consulate might deny you, but O1 is a tricky area. It's a gray area. We've seen plenty of people with O1s still get approved even though they have immigrant petitions. So yeah, you could try the O1 if you need to go fast, or just do the EB1A if you can muster it up. Yeah.
My husband is detained by immigration but did nothing wrong. Is there a chance he'll stay in the U.S.?
He did nothing wrong depends on who. Depends on ICE's interpretation and depends on the immigration judge. If ICE deems him safe, not a flight risk, and he did nothing wrong, and he have legal stay, then they will release him, right? So why did they detain him, and what equity do you have to pull him out? If he's unlawfully present and with no I-130 and no 45, no equity, ICE is not going to release him. Especially in this administration, there's a mandatory detention. So purely being unlawfully here is something wrong. And we've just seen that time and time again. So hopefully that helps.
If I'm a resident and I join the reserve, the Army Reserve, can parents qualify for parole in place?
That will be a Gabby question. I don't remember if reserve qualifies for military parole in place. We've done a lot of parole in place. Most of us do it for the Navy and for the Army. I'm not sure quite reserve. My hunch is that it qualifies because I remember reading from somewhere that it qualifies, but I definitely would want to double check whether or not that qualifies. But parole in place is still happening. Plenty of people are still getting it. We're still getting it. So just double check whether you qualify. It's a 1 minute thing if you search on ChatGPT.
So the person who got detained, he went to go sign with ICE. He has a petition approved and has a wife and U.S. wife and daughter.
He went to sign with ICE. So if it's just checking in, then he's already out. But if you have a U.S. citizen spouse, he could qualify for 45, which might allow him to adjust status, right? 45. So ICE might let him out. It might not be a mandatory detention, but if they see criminal records, if they see something that they really, really dislike, then they might keep him in. But generally, if there's a 45 possibility, there could be a bond option. So if ICE is not really willing to release him on bond, then I would recommend filing for a bond hearing and then have a judge issue a bond hearing.
So have you seen an O1 approval with an approved immigration petition? If it helps, the approved NIW is from 2017.
Yes, and vice versa, right? A lot of people, most people do O1 first and then EB2 NIW or EB1A. But the vice versa happens all the time. We already got it, but something happens, there's an emergent need, we want to come to the US faster to kickstart our plan and reuse everything you submitted, and they get the O1. So definitely possible. But again, O1 does not have immigrant intent. So you should show you want to come to the US to fulfill that thing, but you're not necessarily going to adjust status. You'll still go back to your home country to do the consular processing.
And guessing no success with the national interest exemption to avoid the 100,000.
We haven't done it yet. Worth doing. Maybe in your case, you could do that and the O1 at the same time, right? Again, I think a lot of people do a lot of things simultaneously, and that's okay.
So yeah, this person who's detained, he has the court date, November 13th, so we'll see what the immigration judge says.
Yeah.
I applied for AOS through USCIS. Son, based on parole I obtained through my approved U visa. Do I qualify? So adjustment of status, U.S. citizen son, paroled in approved U visa.
Yeah, sounds good.
What is your billing rate?
We'd like to share. We don't bill by the hour, so there is no billing rate. Our goal is just to complete the case to your satisfaction. We try to get the approval. We work as hard as we can. We're not billing by hour, bill by time. Everything is flat rate. What is our fee? Well, it depends per case, right? Simple things, something as simple as an I-90, a green card renewal without any criminal records, re-entry permits without any issues, and we don't need to mail it to you. Fairly simple, fairly cheap. Something as complicated as like multiple waivers on an application, a lot more expensive. There's definitely a lot more firms that are more expensive than us. I mean, if you just check out our location, we're in Artesia, California, and California. So compared to a lot of big firms in downtown or Irvine, we're a little bit cheaper, but we can't be as cheap as, a firm in like out of state or overseas, right?
If we receive a work permit, how long does it take to get residency?
Most of the time, work permits issued usually 6 months to 9 months after you file, and the green card issued usually a year to year and a half. We have seen a lot of green cards get approved between 3 to 6 months also, and just skip the work permit altogether. So it depends on your case, right? If it's an Adam Walsh, complicated 45 case, you might get a work permit, and then your case might not be adjudicated for 3 years, and so, but I guess if you got a work permit, they're not expediting your green card application. So I would say maybe anticipate an additional 6 months at the very least.
Let's see. There's not an easy way to just add in the Dr. EB1A part back, but I wonder if we can make a separate video on this. It won't be in the immediate future, but I do think potentially in the next couple of weeks. But yeah, we'll definitely make sure to include those questions. I'm not sure why we took it out. If a person receives a 290B, should they refile for adjustment of status?
So the situation is you file for adjustment of status, and then your case got denied, and you're given the opportunity to file a motion to reopen. The question is, should you file a new adjustment of status or file a motion to reopen? That really, really depends on your case. I could tell you there was this other case that filed a motion to reopen that was really weak, and we thought it was going to get denied. It was a different firm that did it, and the client has already been waiting for so long and was extremely angry, and we recommended just refiling 45 and withdraw the previous one. And then miraculously, the motion to reopen got approved, but they got called back to an interview. And so because there was a whole bunch of mistakes that was done on the original application, that's why it got denied. And that's why usually when we see a whole bunch of things that was an error, motion to reopen is not the best way to correct those errors because it was your fault, right? If it was like a discretionary issue, you almost got it, but you just didn't give quite enough. You didn't think it was necessary. You gave 17 documents. They wanted 27, something like ambiguous. Maybe a motion to reopen is good. A motion to reconsider, the officer straight up got the law wrong. But if it was the attorney's fault and messed up on a whole bunch of stuff, we usually don't recommend motion to reopen, just do a refiling. Hopefully that helps.
The EB1A physician, they felt quicker with premium processing than O1, since H1 is not really an option right now. Plus, they have judging experience, peer review, a lot of citations, 100 citations, media mentions as well. So I feel like they're a good candidate for the physician shortage.
Sure, I agree.
I think scheduling consultation is the next step. If I have applied for work as an American citizen, could I still have a chance to get a green card?
If you applied for work as a U.S. citizen, meaning you falsely stated you were a U.S. citizen, and you're now applying for a green card, there's a chance. If the government finds out, there's no chance. There's no waiver. Falsely claiming to be a U.S. citizen for any purpose is a bar.
Any update on DACA reopening?
Nope, but you can still file, right? So just file it in and then see what happens.
So how much would a simple immigration case cost?
We try to do simple cases with just a $250 consultation fee, right? So USCIS has done a really good job. I mean, in comparison to the rest of the world. I know most of you don't study immigration for the globally. I do. We have an office in Taipei. We have an office in Shanghai. Plenty of people try to immigrate out of the US to go to other countries. Trust me when I say this, and I'm going to make a whole series on this. The United States immigration system is arguably the best in the world. With all its brokenness and complexity, it's still one of the best. One of the reasons why it's the best is because they try to make it as clear and concise and as rule-abiding as possible. And so, if you have a simple case, first step, look it up on USCIS, ask ChatGPT to double-check everything, fill out the forms, and once all that is done, and you feel like it's ready, you know how to file for things with DMV, with the library, with mortgages, you're a professional, you're capable, you know how to do it, and you look through everything, and you just want a second opinion just to make sure the I's are dotted, T's are crossed, and that's what the 250 consultation is for, right? We do the strategy. Now, if you want us to review everything, we might charge a little bit more for the paralegal review fee, but again, we're not trying to take on every single case, right? So our base fee is $250. We try to help as many people as we can with that consultation fee.
Do you envision any movement on the H-1B lawsuit by the end of the year?
No.
Yeah, interesting. U.S. immigration is process-driven. In Europe, you can't sponsor your parents, siblings, etc.
There's so many reasons why the U.S. immigration system is probably the superior, the best immigration system that we have on planet Earth.
How much is the paralegal review fee?
We usually charge half of whatever normal application that is. So if it's an EB-1A application, you did it yourself, we'd have our EB-1 paralegal team review it and give you feedback. So it depends on which application. Now, if you go to our website, we actually list all our fees. It's very rare that firms do that. Now, again, we just list basic legal fees. So take a look, check it out. And if you want the paralegal fee, it's basically half of that, assuming you have a simple, straightforward case, right? But again, we start with the consultation. Once we get to know you, we see the case, it's like, okay, you want the paralegal fee, then we quote the paralegal fee, right?
But to migrate as a skilled professional is very difficult to the U.S. compared to something like Europe. And then the whole...
when I say the U.S. has the best immigration system, I did not say the fastest or is the easiest or is the most cost, I'm saying it's the most maybe thorough, thought out, policy-driven, public interest. Sure, there's other countries. You can buy a passport and become a citizen in a few months, right? That's way easier, but best doesn't mean easy, right? So it's the Dodgers right now, the world champion, they're the best. It's not easy to be a Dodger player. You know what I'm saying?
And then like the whole categories, right? So if you're born in India or like China,
right,
Philippines, that kind of thing too.
Right. So it's definitely not the fastest, definitely not the easiest, but at least in my opinion, it is the clearest, it is well thought out, it is policy driven, it is forms, it is clear.
Yeah, there are some like weird vestiges there, right? Like the 7% cap, that's the nationality?
There's a lot of things that are conflicting within each other because of all the politics, a lot of it, right? And there's illegal immigrants, there's undocumented people, there's people who have violated and who are applying for waivers, and there's people on parole and visas and green cards and citizens being revoked. But that's part of why it is such a great immigration system, because they had to take into account everything and create policies and laws for everything, right? Other countries, they just kick you out. It's over, right? There's no like waiver. What are you talking about?
If you live in Texas for DACA, would you recommend moving or what would you suggest?
Yes.
Is K3 worth filling out after the I-130?
Is the K3 worth filling out after the I-130? That's a very specific situation. If your I-130 is already pending, you want to come faster, I probably have to know your situation a little bit more. And my recommendation, if you're booking a consultation on this specific issue, pick the Spanish department, because the Spanish department does most of the case. I don't know why. I don't know why, there's more Ks in the Spanish department than any, but it happens at our firm.
I have DACA, married to a U.S. citizen for 15 years. Can I adjust my status at the moment?
If you entered legally, even if you overstayed, like if you came as a baby with a tourist visa, you have a stamp on your passport, then you can adjust status. If you haven't by now, most likely you didn't enter legally, right? Or somebody somewhere would have told you you could do it. But, double check. If you did enter legally and you have proof of that, then you could adjust status. But assuming you don't, then you apply for advance parole, and then you execute the advance parole. You leave the country, come back in, pay that new $1,000 fee that we're talking about this morning. And then once you have a lawful entry, then you can apply for adjustment of status.
How long have you been practicing?
I have been practicing as an attorney since 2012, once I passed the bar exam. But again, I've been interning since I was in high school. So I graduated high school in 2003. So I've been interning, doing like 751 affidavits and stuff since 2002 and going to AILA conferences since 2003.
Does emergency medical count as a public charge?
Public charge usually is referring to people who are a debt to society or causing a burden to society, so they cannot get adjustment of status, they cannot get visa benefits because they are a public charge. You're a threat to the United States. So I'm assuming your question is you've used public emergency in the past and now you're applying for a benefit. Usually the consulate or the adjustment status immigration officer would want to see you are either paid it back or that you are completely safe from doing that ever again, right? So for example, you dial 911, okay, and then what services did you use? Did you pay it back? Was there insurance, etc.?
So after the $250 fee, you can give me a customized quote for the EB-1A or O-1 case based on the situation?
Absolutely. If you take a look at our website, on the schedule page, there is a video of me talking about what you get during the 250 consultation. And our goal is to be able to at least give you a map of strategy of what's the best option for you. We'll give you a checklist of the different things that's pertinent to your case. We'll give you a blueprint, which is what we call is the retainer, if we can do the case, right? This is how much our fee is, this is the flat fee, and this is the process. And then again, if you do the paralegal, it's just half of the legal fee, right? And then a timeline. If you want to do this case, if you want to be in the US by June of next year, for example, so your family could go to school and stuff, well, or your kids want to go to school, well, then you want to file your case by maybe March, and then you can get an approval by April, and then so you could go to consulate by June, right? So you kind of work backwards. So during the consultation, we'll go over all of that. And again, our goal is to try to help as many people as we can during that consultation time. It's not a sales call. We're not trying to just take on my cases. We actually have more than enough cases that we can handle at the moment for almost all departments. And so again, consultation is the best way we can help as many people as we can. And then in extension to that, doing these live events where you guys ask me questions and I try to answer as much as I can to help, right?
We are still taking on EB-1 cases, is that right?
We are, yeah.
Is losing your job considered severely financial loss for expedited processing?
No.
Do an I-130 for my wife. We just got DQ'd for California. How do I find the coming possible interview date?
Read that question again?
Doing I-130 for my wife. We just got DQ'd for California. How do I find the coming possible interview date?
I don't know what DQ means.
Like disqualified?
I know, but I don't know what that means. Like, yeah. I was an athlete in high school too. So DQ is like, yeah, you got DQ'd, so you leave the race. But like in immigration terms, not sure what that means.
Do you help U.S. citizens get other kinds of citizenship to be for other countries? Oh, document qualified.
Oh, okay. So read the question again.
Doing I-130 for my wife. We just got document qualified for California. How do I find the coming possible interview date?
Oh, you don't. You can't. You have to wait until they give you an interview date. And then if that date doesn't work, then you extend it. Yeah, so there's no way to find out when you're scheduled until you're scheduled.
Do you envision changes to the EB-1A criteria soon? They have mentioned it?
Yeah, I definitely think it's going to change. I mean, this year already completely changed so many things. Last year, a lot of changes started to happen towards the end of the year. I mean, and a lot of changes happened. A lot of changes happened at the EB2 National Interest Waiver Department, but it is pouring over into the EB-1A category. With Trump's gold card standard, right, that's going to heavily affect EB-1As too, because essentially the gold card is saying that they are EB-1A qualified. And so that's going to, make a big impact. And that's why a lot of people are doing the EB-1A now before the gold card officially goes into effect, because they're basically going to take all the slots away, right? So if if 10,000 people applied for the gold card, well, and then you filed your EB-1A afterwards, then, your case is going to be like behind all of them, right?
If I entered without inspection, can my husband petition for me?
If your husband is a U.S. citizen, they could petition I-130 for you. That doesn't give you any lawful status. But once that's approved, then you can go through the waiver process and then get a green card that way. But it is long and it is tedious. But that is one of the only ways to get a green card. That is not having an I-130 approval does not prevent ICE from picking you up. Having a 601 approval doesn't even prevent ICE from picking you up.
Do you have attorneys who handle immediate relative petitions, like parents of U.S. citizens?
Yeah, those are family-based immigration cases. So if you go on our website, there's Spanish family, there's Chinese family, there's English family. So you just pick your language, pick your department. Those are all very, very basic, unless it's complicated, right? Because family-based petitions could be quite complicated too.
Do you suggest doing advance parole even if my husband has a closed conviction under 1 ounce of POM case?
If it's anything drug-related, I would discourage from advance parole.
Does the president really have the power for that gold card thing? Doesn't changes to the law normally be made through Congress?
Great question. Here is the nuance of everything. EB-1A is saying if you are extraordinary, you can get a green card, right? But what does it mean to be extraordinary? Well, there's those 10 factors. Do you know what the 11th factor is? The 11th factor is comparable evidence. It's built into the law. It's a catch-all, right? It's a catch-all comparable evidence. If you have something that is not like a membership, that is not, like technology changes, that law was written in the 70s? The world has evolved that just because you have publications and just because you're on the newspaper does not mean you're extraordinary, right? If Kim Kardashian endorsed you, maybe you're extraordinary, right? And so if you have comparable evidence, well, what is a comparable evidence? If the president says you donating, you gifting $1 million or $2 million if you're a company to the United States and bought bonds, that means you're extraordinary. If you have a president's letter recommendation endorsement, does that qualify? So the president is not changing the law by issuing the Trump card. Now, this Trump card that he announced and the USCIS is working on right now is vastly different than the Trump gold card that he announced that he was going to do before he was elected, right? So before he elected, he said he was going to do this big grand thing and everybody doubted him. And now he gives a new version of it that is completely compliant within the law, but it's using up EB-1 slots. So unfortunate to the people who are truly extraordinary, now all the wealthy people are going to take up that slot. Is that good for the country? Is that bad for the country? We have a rich person right now running the country and thinking rich people are better than everybody else. So go figures.
So it's kind of how you interpret extraordinary. The law is the same, but the interpretation is different.
Right.
And he's the one that enforces the law, so yeah. For the DS-260, was my wife supposed to upload any of my vital documents, like birth certificate?
DS-160, you don't upload.
260.
Oh, 260. 260, you are supposed to. DS-260, well, to clarify, at the NVC stage, you should have, National Visa Center stage, you should have already uploaded everything. And then DS-260, filling everything out, that's with the consulate. So, somewhat separate step, but it's not in the same form. I don't know if that helps.
I'm in the military. How fast can I get in to schedule a I-130 interview for my wife and mom?
I'm assuming you're talking about military parole, right? Or else military doesn't even come up, right? So if you are doing military parole and filing an I-130 and trying to do a 45 adjustment status interview, every service center is adjudicating this a little bit differently at the field office, and they all have different requirements, and it's not public, so that's extremely frustrating and annoying. But it is happening. We have seen some cases as fast as 9 months. Again, those are like super fast. Military parole, expect them maybe a year and a half or even longer. And again, a lot of the delay is not because of your parents, not because of you, not because of the present policy. It's just because the service centers, the officers don't really know how to do it, and there's change in personnel, and there's people leaving, and there's no clear guidance, and every service center does it differently. Some want a clear written statement of the entire history signed, some don't, right? And so the best thing to do is just to prepare the case well and check with the officer at the service center.
So we just did some videos on the citizenship test, and I think it's really interesting because on citizenship testing, right, you would think in the law, the judges, the judicial branch interprets the law, right, not the executive branch. So the executive branch interpreting the law to mean...
Yeah, so in this context, we're talking about the EB-1A, your extraordinary ability, but who is to decide what does it mean to be extraordinary? Congress has written into the law comparable evidence as a catch-all. So the law is there, it's flexible, it is, and every administration, USCIS, they adjudicate these differently, slightly differently, and that's within the purpose of Congress, right? And the courts would completely agree with that. Like, it is wise to have agencies be able to interpret and be flexible with the times. So all Trump did was say, and again, he's one of the only president has ever done this, basically say, well, if you give $1 million to the government and buy our bonds and help us out of a crisis, I think you're extraordinary and you can qualify. Basically giving him the seal of approval. That is pretty, I want to say ballsy, right? Is it the right move? Is it the wrong move? It's very businessy. Is it good for the United States? Is it set a bad precedent? I think I could see arguments on both sides. The U.S. is heavily in debt. Buying $1 million and we're $1 million less in debt is a good thing. But the downside is if 10,000 people or more, depending on who you ask, estimates, if 10,000 people clog up the EB-1A system and now we have a flood of really wealthy people in the country
who aren't going to be necessarily...
Is that better for the United States? So now scientists, doctors, all these other very capable, important people now have to wait far longer just because they're not rich. What's more important? And again, that's for debate. Maybe some people will say, we have the best doctors, we don't need scientists from anywhere else. Okay, that's a perspective, and therefore what we need is more rich people in the country. Is that true or not true? I don't know, right? But if these rich people give $1 million and decrease the debt, but then the government misuses it and creates a bigger deficit by, government waste, I don't know. It's really hard to know what exactly is best for the United States going forward. And that's why it is so rare for the United States president to come up with something like this, to say, basically prioritizing wealthy people. But, he's not a dumb guy.
What is your best advice I can give to my wife for her interview? That is the DS-260.
The S-260 wife, consulate overseas, she should know your life inside and out, especially as a woman, right? I mean, come on. Women know everything, generally speaking. And so, first date, how long have you guys been married? Your mother, does she have your contact your mother? Your siblings, what high school you went to, what college, your exes, if it's a marriage-based application and they're going to the interview and she's overseas and you guys been doing long distance, she should know a lot of things about you. And so definitely practice and rehearse that and be able to explain what your life is going to be like in the future. And if there's anything slightly off about your relationship, for example, we just saw a case like this tonight, 40-year-old man marrying a 40-year-old woman who's been friends and partners for a long time, but now they got married. The wife just didn't know that much about the husband's situation, and the case got denied, and potential fraud and misrepresentation. So she should definitely know a lot about you.
Any key things you should definitely know?
Key things? I mean, here's the thing. Here's what the officer knows. The officer is going to look at the DS-260, so everything there, it's right in front of them. The officer is going to spend about 10 minutes reviewing everything before they call you up. The officer might have done a background search on you, so they have all the information there, so they're looking through it. And then when they see the spouse, it's a normal officer, might be a 25-year-old, might be a 30-year-old, might be a first-time job, might be, a second. These are consular officers. And so what are the questions that they will ask her, right? So you could just pretend that this is what they know, what they're going to ask, right? And so how did you meet? When's the last time you saw each other? When's the last time you guys talked? So there's nothing that they're definitively going to ask, but that's something you have to prepare for. And again, be confident, right? If she's extremely timid, that might be tricky.
What to do if you reapplied for DACA working permit, but no answer yet? It's been 2 years.
I don't know. I mean, if you're reapplying, people should be getting it. And so if there's something wrong and you can't work, you might want to sue them. You might want to do a mandamus action because it is your right? Now, if it's a first-time application, well, they're not, adjudicating it. You can file, but they're not adjudicating it, right? So, but if you got the work permit before and then you're renewing it and you still haven't gotten it, that's pretty crazy. I mean, most of the time they approve it within 6 months.
I have DACA. I did Advance Parole last year. My son will turn 21 in June. How do I adjust status?
Apply for adjustment of status. So for the form is 45, right? You just type in the browser USCIS 45, print out the instructions, print out the application, and they have checklists, they have the forms. It would take you an hour, 2 hours, go through everything. And again, you're a DACA recipient, and so everything you submitted for DACA, just carry that over and put it in the application, prepare well, you should file, and then within maybe a year, you should be able to get your green card.
The path to immediate citizenship bypassing the green card via military service doesn't exist anymore, right?
Not that I know of, but that is more of a Spanish Department Gabby question. She does a lot of these, but not that I know of. And again, most of the time, military citizenship is done at the military, right? Like JAG, they would directly do it for you. And so it doesn't go to the private law office, private bar that often. I know it existed before when I was studying for the immigration test to be a specialist, but I don't know if it's still valid. We haven't seen it in a long, long time. But again, normally it just doesn't ever flow to us. But parole in place does, right? So helping your family get green cards by being in the military.
After filing I-130 and receiving a receipt notice, what's next and what can you do to help speed up?
Nothing we can help speed up unless there's an extraordinary situation that you want to expedite it. But, 99% of the time, they don't approve expedite requests. So you wait, right? And you could prepare for the next step, right? So if you're qualified to do adjustment of status, you could start preparing for that. So when I-130 approved, you can immediately file, or you can prepare for the waiver and file for that.
Was called MAVNI, Military Accessions Vital to National Interest.
Okay. Yeah, I remember reading and studying on it, but I don't know if it still exists right now.
I've been waiting on I-130 since March 2023. Is this normal?
2023. So if it's a lot of I-130s, I mean, it's crazy. You check online, some say it's over 50 months. So it's over 4 years for a lot of these cases. Some cases, immediate relatives could be 2 years. Again, like I said, immediate relative, I-130, 45 could be as fast as 3-4 months that we see. But if it's like a longer petition, sibling petition, it could be 4 or 5 years.
Would suing them for a 2-year delay on DACA renewal put one at risk of deportation?
No, you're suing in federal court and you're suing USCIS, so it's not really dealing with ICE. But let's say you have a criminal record, ICE could then refer you to ICE, and then you will be at risk of deportation. But I can imagine we have plenty of DACA clients who are doctors, who are lawyers, who are very involved with the community, and they've been working and they have clients and they have patients and people really need them. And what's up? Like USCIS, you lose the file, right? And so exhaustion remedies first. You don't have to, but I would recommend that, right? Call USCIS, do the InfoPass, do the EMA contact, use the ombudsman, and try to push that through. You can't, then the worst case scenario is you do a mandamus action to force them to adjudicate your case. But that's again assuming they're supposed to, right? If it's a first time filing, then they're not supposed to, so you'll be useless to sue them.
Do you know a way around the permanent bar for multiple entries?
Oh, great question. This is a segue to our success story today. Okay, so we're just going to jump into that. Today's success story is about somebody with that bar, and they got referred to detention, and they have an immigration judge, and the case was closed years ago. Recently, it just got reopened in June of this year. We went to the first hearing, and then it got calendared in October, just a few weeks ago, and then the 45 got approved. Okay, so again, backstory, client came into the country with a tourist visa, overstayed, multiple entries. Now there's a 3-year, 10-year bar, arguably a 10-year bar. Child is a U.S. citizen, filed for adjustment of status. USCIS denies the case. Sorry, you need to, you have this permanent bar. You need to leave the country, and referred to immigration court. And the immigration court, because they saw the adjustment status potential, closed the case. Hindsight is 2020. Everybody will say you should have just applied for adjustment status at that time. You shouldn't have closed the court. But who's to say, right? Hindsight is always 2020. Should have done it back then. You would have gotten a green card. You would have been a citizen by now. But they didn't do that. Case was closed. At least they stayed in the country with their U.S. citizen children and spouse and everything. Fast forward till this year. File for parole in place, because if the issue was USCIS and the courts did not accept that they had lawful entry, even though they entered with a tourist visa. File for parole in place because, again, the children was serving in the military. The parole in place got denied. Why? Because USCIS said there was lawful entry. Oh, parole in place said there's lawful entry, and the parole in place was denied. Hallelujah. At that time, the court reopened the case, and now there's a hearing. At the first hearing, just within 1 month of getting that motion to reopen, Nicholas, Emily went and presented everything to the judge. We have the 485 ready. We can do the merits hearing right now. Let's do it. U.S. citizen child, adjustment status ready, lawful entry. What's not to like? No criminal record, good moral character, wonderful family, wonderful mother. The judge calendared as fast as possible within a few months. And in October, the case was approved. There's so many takeaways from this, so many. First of all, if you get recalendared, it might not be the end of the world. It might be the perfect opportunity to start a new beginning, right? And again, luckily for this client, they were working on this case with the parole in place and preparing everything months before, right? So that's the first thing. The second thing is, if you have a choice between going to adjust status with the court or adjust status with USCIS, the conventional wisdom, most immigration lawyer, ChatGPT, a lot of people will say, do it with USCIS. Everybody likes USCIS. There's a whole process in place. Well, not in this case, right? Actually, for the people who go day in and day out in immigration courts, If you have the window of opportunity, do it at the courts. Why? Because the judge has the authority. The judge is already doing the merits hearing. If you have a clean case, let the judge do it. Get it approved. The card comes. You can skip that entire transfer process, which might prolong the case by another half a year to a year plus. USCIS, immigration officers, a lot of them are not necessarily attorneys. Most of them are not attorneys. Some of them are, and they don't necessarily like to deal with these complex type cases. But a judge is used to doing way more complicated cases. But when they get an easy case, such as a U.S. citizen, lawful entry, or paroled in, and can file for adjustment and everything qualifies, to them it's an easy case. Get it off the docket, get approval, check their quota, feel good day, right? And so again, conventional wisdom, if you have court or you have USCIS, you want to deal with USCIS, but that's not always true. If you want things faster, this case shows it, right? June, the client's family couldn't sleep. And that was during like the raids, couldn't sleep, motion to reopen, calendared, stressed the heck out. But a couple months later, they got the green card. Been waiting for years, I love the legal strategy that was done in this case. Emily was the mastermind behind this, essentially filing for parole in place, trying to seek a pathway there. Got a denial, unfortunately, but with that denial notice, USCIS admitted that there was lawful entry. And with the lawful entry, now you can go give it to a judge. Just love the whole nature of this. So again, I'm answering the client's question, not client. I can't say you're a client yet because, you're not a client. But a viewer, a fan, asked, if you're in the U.S. and you have this bar, can you still adjust status, right? Or if you're detained, is there hope? Well, yes. So that's a success story for today. Just want to share all the details. Hopefully that helps. The advice, I was just on the phone with Nicholas and Emily talking about this and strategizing about it. Because again, the case is not over. There's family members. There's all sorts of other things that's going on. But the key takeaway is, if you have a case that has been closed in the past, right? If you have a case, you've been here and you were in deportation proceedings and the case was closed, you are actually in a better position than if you're purely 100% undocumented. Because if you're purely 100% undocumented and ICE picks you up, now you're put through the worst of the worst system that exists, right? Everything is bottlenecked. There's a bunch of bureaucracy, all these fines, there's mandatory detention, all sorts of things. But if your case has been closed, you're essentially safe. But you should start preparing your case in case they reopen it. And if it's reopened, you have a good marriage argument and potentially can get the green card. There's a lot of pressure on the government to reopen a lot of cases that they closed in the past decade. You have time to prepare. You never know when they're going to reopen. It's a matter of if and not when. They're going to open it. So better prepare now.
Okay, that is our time, everyone. Thank you so much. We will be here next week.
And next week, we will actually be at the Southern California American Immigration Lawyer Conference in Long Beach. We'll be there live filming the same thing, the same time period from 12 to 1. But next Thursday, Friday, Saturday, we will be at the convention center. We will be at the Long Beach Convention Center at the Westin. We'll be talking about immigration. We'll be filming about immigration. So if you guys have any questions, feel free to ask. Feel free to visit us. Take care.